30 days, right? So during this time, if in case you are of the opinion that the notice has been wrongly served on you, wrongly issued to you, you can obviously contact your lawyer with regard to the handling of this particular matter, because most in most cases what happens is the 91 notice is issued not just to seek any kind of documents, but indirectly the police also try and secure the person who is concerned with the whole case, right? So in the hope of getting the person, they sometimes issue this 91. This is a kind of mischief where police personnel they adopt. But if in case you genuinely think that it does not concern you, it does not involve you, you can straight away consult your lawyer, and probably if there is any issue, you can ignore the notice, right? But if in case you are connected with the case, it is always advisable that whatever documents are in your custody, produce it. Produce it before the court. Or if the concerned person thinks that he is guilty of any offense, I would suggest first procure anticipatory bail and then go to the police station. That is always a safer option, right? I hope I answered your question.
Sir, section,
Thank you so much.
Yeah.
sir, section 91 CRPC is telling about summons, no, sir? Is it notice and summons are same?
Yes, sir. Notice and summons are the same. Summons is basically another word for issuance of notice itself. So you will see the word usage of word summons basically is calling upon someone to do certain things. So that is what basically means summons, right? So we'll come back to the topic. So this was just an example. Section 91 is just an example, just to show or give a comparison. Coming back to the topic with regard to the legal notice, we'll now move on to the consequences of non-delivery of legal notice. So we'll go to the procedure a little later on. What happens? No, sorry. Yeah, what is the procedure for issuance of legal notice? So, as we have already understood that legal notice consists of a set of facts, it is a kind of intimation demanding from a person to do certain things in a certain way within a reasonable time period, right? So now, how do we deliver this particular legal notice? First of all, we have to understand that a legal notice through the development of technology, we are now able to deliver notices via WhatsApp, via emails, via so many telegrams, so on and so forth, right? But how did this actually emanate? The first aspect that has to be understood is please read or refer to section 27 of the General Clauses Act, which basically lays down that any kind of intimation which is basically issued will be through a registered post, right? This particular General Clauses Act was written way back in the 1800s, and it is still relevant for the present day. So what most lawyers usually do is at the time of issuance of the legal notice is not just given, put in a cover, sealed cover, and then put in a post box. We don't do that. What usually we do is at the time of issuance of legal notice, a proper registered post acknowledgement cards are attached along with the main document, that is the courier or the parcel, right? Wherein it will clearly mention the details of both the sender as well as the receiver. This acknowledgement card, that is the RPAD, right? This RPAD helps us in understanding whether the particular document has reached the addressee or not. If in case the particular document has reached the addressee, then there will be a signature which is taken from the concerned person who has received the document on the acknowledgement, and that acknowledgement comes back to the sender, right? And this particular document forms a crucial aspect at the time of institution of a particular complaint or a case. It becomes more significant in a check bounce case, especially in a proceeding under 138, where you will have to showcase to the court that you have issued notice, and such a notice is either served on the other party or it has come back without being served on the other side, right? So there could be various reasons for non-service of a legal notice on the particular person. It can be due to the reasons of addressee leaving that particular address, or probably he has not residing in that particular address for a long time. Probably he is not in that city, he is still in that house, but he is out of town probably from several years or several months, right? So that is when you will receive the particular document as unclaimed, right? So these are the certain reasons which is usually put in the legal notice, where if in case it is not served on the other side, right? It can be the place where addressee has left. It can remain unclaimed. It can also be refused by the other side. Suppose a notice is issued on me, and the postman comes to deliver the particular notice, and after looking at the postal address, I realize that it has come from my opponent. So what will I do? I will say, no, I don't want to take the notice. So the postal authorities, being an independent authority, they will make an acknowledgement in the postal receipt that comes back to you, saying that the person has refused to take the notice, right? So when refusal is mentioned, or when the notice says that it is refused, it basically means the other side had a knowledge of the particular notice, and that is the reason why he has refused to take the notice, right? Insufficient address could be another reason why the legal notice was not probably delivered. The other reason is again door lock, and there could be other plethora of reasons that can be mentioned in the legal notice. Now, what will happen if the legal notice does not get delivered? Or what is the consequence of non issuance or non delivery of legal notice? The consequence of non delivery of legal notice, firstly, is that it depends on the reasons. If it remains unclaimed, if it remains refused, or if it remains that the addressee has left, right, it can be deemed that the legal notice is served on them, right? So if you read through the provisions of Order 5 of the Code of Civil Procedure, right? Order 5 of Code of Civil Procedure, it basically deals with the aspect of service of summons and notices, right? So it also lays down the procedure of how the service has to be done, or when it can be considered as deemed notice, or when it is considered as not sufficient or insufficient notice. So all these aspects are very crucial at the time of initiation of the case. And please understand that if any of the reasons which basically uh, provides that the service of notice is sufficient, only then it is better to institute the case. Or else, sufficient notices have to be given to different addresses. Suppose I am of the opinion that the other side is residing probably or has different addresses in a particular city. I am residing in Bangalore, right? So
Yeah,
I
Baba.
have
Yeah,
multiple
Baba.
addresses. I have my office address, I have my home address, right? I have my friend's office address. So there are multiple places of business and multiple residential places. So if the other side who is issuing the notice is aware of the fact that there are multiple addresses, then it is always a safer option to issue notices to all those addresses to which a particular person has knowledge of, right? Because at least there are chances of the notice being served through either through to one of the other addresses, right?
Excuse me, sir.
Yes, please.
Yeah. So I've read also in this context that
Hmm.
many a times it also happens
Hmm.
that the person who is delivering the notice,
Hmm.
if he is not finding anybody in the house, so he can keep that notice in a secured place. I have read
Hmm.
this, right? So,
Yes.
in that case, how will the other party, as if I am the lawyer and I have sent it the notice, I'm the postman person, he has kept that in somebody's building in a secured place. How will
Hmm.
I get acknowledged that my notice has reached that particular person?
Right. So what you're saying is just a post. It is not a registered post. Because what happens in a registered post is that while you are issuing a registered post, there is a duty on the postal authorities to ensure that the notice gets delivered. Because that is the reason why an AD card or an acknowledgement due card is attached along with the postal cover, right? So please
Yeah.
understand, if it is just a regular post, you just have to drop it in the post box, and probably it'll go at its own sweet time. Whereas in a
Hmm.
registered post, there is a mandatory thing of delivery in within depends on the distance again. Delivery period of 3 to 5 days, right? And during these period as well, whenever it has reached the other city, and if the postal authorities are just trying to deliver to the other party, so you will see there will be multiple entries on the postal cover. So they will put a date, they will put a reason as to why it was not delivered. So there will be like multiple attempts on a daily basis. They may go probably 2 days or 3 days once. They may go to that place. They may visit the place, and they will check whether any person is there or not. Right. So your question of keeping the notice in a particular place and coming back, that works for a regular post, but not for a registered post. Right. I hope you understood.
Yes, yes. Thank you.
So now coming to the last aspect of presumption that is provided under the Evidence Act. Now, as I was mentioning in the initiation during the beginning of the class, we have to be very clear. We have to be concise with regard to the details that we are putting in the legal notice. Now, suppose you are issuing a legal notice under Section 138 of the Negotiable Instruments Act, and you probably have very little knowledge of the address of the other side. How do you gather address of the other side when probably you don't know exactly if there is no clear details about his business, or there are no clear details about his particular address itself? Then what is the remedy that is available to you so that you can issue a legal notice? The first and the foremost thing that is available is first to verify the address that is given in the bank statement, right? Because what happens is, I suppose the concerned person has issued a check from his ICICI bank account to me. So I go present it in my Union Bank account, right? For me to get the address of the particular person, I have to go visit the ICICI bank itself. And if I have to ask the concerned banker, though it may amount to a right, but if you show us or if you give sufficient proof that you have to issue a notice, or probably you have to you have a against him, particular bank may not revoke the detail. That is the first and the foremost thing. If in case, if it is a registered business, right, you can immediately approach the concerned authorities, which includes the MCA, that is the Ministry of Corporate Affairs, wherein you can do a MCA search, probably pertaining to the company's name, probably the individual director if he is a director, right? So using all these details, MCA search is one of the best search which you can use for your toolkit to get the address of the place of business or the particular individual who is operating, right? This basically provides details about the company, LLP, or any other kind of entities which are basically functioning or having a CIN number. The other authorities probably which you can look at is your local municipality itself, right? If you approach the local municipality with regard to there being a proprietorship business, they would have issued a trade license, right? So using those details with regard to the trade license or the holder of the license, there will be certain specific prescriptions or the stipulations issued in the license document, which will give out the details, right? So you can ask your client to probably get all these details by doing a basic due diligence, right? By understanding that where all you can approach, right? MCA is an easy tool. Local municipality is an easy option that you can easily approach, right? So in order to procure all these details, you can also approach the concerned sub-registrar office seeking for revenue documents, concerned municipality seeking for revenue documents, right? Not just the trade license. For the GST details and the holder of the GST license, right? So all these things are basically details which are essential for the purpose of fulfilling the criteria of a statutory notice. Now, why am I talking about the evidentiary aspect? If you read through section 114F of the Evidence Act, it basically lays down a presumption in favor of a particular person who is issuing a notice. Suppose I am a lawyer and my client has asked me to issue a notice. I have done all the basic due diligence, and after doing the basic due diligence, I have issued a notice, right? But despite that, I have not been able to get the notice served on the other side, right? That is when the presumption will be considered in my favor and not against me, because I have done the basic due diligence, I have fulfilled all the basic requirements, and after doing all these things, I have issued the notice to the proper address. It is not an incorrect address that the notice is issued to and it remains unserved, right? So the whole point of doing the due diligence is to ensure that the notice will get served on the other side, right? So these are some of the points which are essential for a practitioner to understand why or the significance of issuance of the legal notice, right? So I think I've been able to lay down a fundamental aspect of the issuance of the legal notice. If there are any questions, please ask. We have I think another 5 minutes left. I think I exceeded the 40-minute duration, but please feel free to raise the question.
Yes, participants, if you have any questions.
Is to represent the check and get the notice issued. Because what will happen is, if the notice is issued after the time limit gets expired, then it will not be considered as a valid notice and it can be fatal to your case. So it is always better that a check representation happens. If it is again within the duration of 3 months, it has to happen because the check bounce cases are very time intense, and it has to be in prescribed time limit itself. So if in case it does not happen within the prescribed time limit, then it can be fatal to your case and ultimately leading to the dismissal of the case itself.
Is there a mandatory to inform the party to represent the check, sir?
So in order to get the limitation back, so in order to issue the check bounce notice within a period of 15 days, right, it is always a safer option to ask the party to represent. Because sometimes what happens is it is the fault of the clients where the check would have been deposited within the time period, but they would have approached you at a later point in time, probably after 15 days or whatever is the stipulation under the. So at that point in time, it is always a safer option to ask the party to represent the check and approach you immediately so that you can get the notice issued within the prescribed time period.
Thank you. Thank you, sir.
I see there is a question in the chat box which says, what is the procedure to government authorities to obtain the address of the other party? Ma'am, in order to address this, I think you can probably refer to the basic option of filing an RTI. Right to information is one of the tools that have been provided, and you can access any kind of public records, right? Any kind of public transcripts that are made available to public, right? Trade license is something which is a public record and that you can access it easily. So through RTI, or if you are residing in Karnataka, I can say you can approach the concerned government authorities under Sakala. Sakala means it is a Kannada term, which basically means a stipulation to do a certain thing within a prescribed time limit. The government itself has put that obligation on itself. So Sakala is a state legislation. RTI is a central legislation which you can directly utilize. Right? I hope I've answered.
Hello. Hello.
Yes, sir. Please go ahead.
Sir, whether the banks are legally bonded to disclose the account holder name in the event of any check bounces, or it's just a moral responsibility of bank?
It is not a moral responsibility, because again, what usually happens is the bank is not in a position to give out the details. Whatever details is available with the bank can be considered as a personal information, right? More so in some cases as a sensitive personal information. Especially, bank will have the record of Aadhaar, the bank will have the PAN card records, date of birth, residential address, right? So all these are sensitive personal information, which, if in case it is given out, may amount or may infringe the right of the other parties, right? So bank is under no moral obligation to give out any kind of details. However, if in case you are probably giving sufficient cause, sufficient reason as to why you are seeking the information, then the bank may be probably obligated to give out the details.
Okay, sir. Thank you.
Right. So I'll just address the two last questions. One is the question pertaining to how much minimum intimation period can be given in a notice. The second one is, does RTI apply to government offices, or we can send notice to private company for details of husband's salary in section 125. So in order to address the first question with regard to the minimum intimation period, it depends on the gravity of the subject matter or the seriousness of the subject matter, right? Suppose if there is any kind of emergency where probably you can give a time limit of 15 days, right? As I was mentioning, the statutory stipulation under section 138 is 15 days itself, right? If in case, if suppose the party is seeking for a partition of the family properties, right? At that point in time, you can give a notice period of 30 days. In cases where a defamatory material is probably published in any kind of social media or any media platforms, in that time, you can give an intimation saying that within 3 days or act immediately. Because if you are issuing a notice for infringement of trademark or infringement of a copyright, you issue a cease and desist notice. In the cease and desist notice, there is a stipulation of doing it immediately, right? It may not give any kind of stipulation with regard to the time limit, but it requires the party to do it immediately, right? Suppose as soon as you get the knowledge of the copyright infringement happening and the notice gets issued and the notice is served today, I have to act on it immediately. If I have any intention of acting on it, I have to act on it immediately, right? Because the notice prescribes so. If in other cases, it depends on the time limit, whatever the parties consider is appropriate, right? But the basic usual time limit that is given is 15 days to 30 days, right? Coming to the second question, does RTI apply to government offices, or we can send notice to private company for details of husband's salary in section 125? This is an interesting question, but I would request Mr. Darshan to please read through the provisions of the RTI Act, because RTI Act is only applicable to the government authorities. It is not applicable to the private entities at any cost. However, again, there are certain exceptions. If it is a government-funded, government established, or if there is any role of government in such private party or a private company, at that point in time, the RTI may become maintainable, or else the RTI is only applicable to the government. In the nature of cases where maintenance is sought, especially in 125 cases, right? When a section 125 petition is instituted before the magistrate, right? At that point in time, it is advisable to probably file an RTI. Rather, you can resort to approaching the court itself. Under 125 petition, you can ask the court itself to direct the other party to furnish salary details, or probably if there is any kind of attachment order, the court itself will issue the concerned intimation, right? So I hope you are getting the point what I'm trying to convey. Because RTI, even though it is applicable only to government offices, right? Under 125, you have both the options. But for a private entity, you cannot resort to RTI. Rather, you will have to ask the court only seeking for a direction to furnish the necessary bank details or any kind of monetary transaction details that is available with the private company, right? So they cannot deny a court summons. So they will have to furnish the details. So that becomes an easier option, right? So I hope it was a fruitful session for all of you. I believe I have addressed most of the queries. I apologize if I'm not able to